Great. Okay. And the appellant is Mr.
Thielhelm.
Thielhelm. All right, you pronounced that really well. I was not going to do as well.
I've had 60 years of practice.
All right. All right. So you may proceed. 5 minutes, good for rebuttal?
Your Honor, if I could reserve, I think 3. I think I've got a decent amount to try to cover.
Okay.
At least I hope I do as the appellant.
All right, got it.
So may I please the court? My name is Rob Thielhelm. I'm with the Orlando office of Baker and Hostetler, and I'm here on behalf of the appellants, Onassis Burris and Tony DiCaria. It's our position that the trial court committed reversible error when it failed in its role as the gatekeeper under section 768.72 and allowed the plaintiff below, the appellee here, and the tenant in that circumstance to assert a claim of punitive damages, even though the tenant didn't establish either the pleading component or the evidentiary component necessary to be entitled to plead punitive damages. The courts, at least it's a meaningful burden, and that's why the courts in the statute put the trial judges in the role as gatekeeper. They're not allowed to plead right at the outset punitive damages in a case, obviously. And this court has held that, and other courts as well, including the Florida Supreme Court, that clients like mine have a substantive legal right not to be subject to a punitive damages claim until there has been a sufficient showing, a reasonable showing of a reasonable basis to award punitive damages. And this court, beginning back in the Bernador case, at the very least, if not earlier, all the way up through more recently, Judge Saud's special concurrence in the Medfast case, which I think was filed as supplemental authority by my colleague here. What you need is both that pleading component and the evidentiary component. If you fail on the pleading component, then you don't even get to the evidentiary component. And we submit that's the case.
How do you say the pleading component? Do you mean the denial of the motion to dismiss, the initial, that denial that complaint is insufficient, or how did they fail in the pleading requirement here?
Both in terms of the failure to plead facts to establish the either definition of gross negligence or intentional misconduct under the statute, as well as the fact that the complaint also suffers from inherent defects in terms of the independent tort doctrine and bars the claim under the independent tort doctrine as well as the non-reliance clause.
And is that something we can look at here?
I believe it is.
Of review?
I believe it is because when you file a motion for leave to amend, you have to be able to establish that it brings up all of the elements of the claim. And if the court was wrong on the motion to dismiss, well, fine. But now you're at a stage where the plaintiff is asking to amend their pleading, and if the court is now, we have an appellate right at this stage to bring the sufficiency of the pleading to support a punitive damages claim. And I would submit to this court, and do continually submit to this court, that there was no sufficient basis in the complaint, whether it be facts or basic principles of law, to establish a justification to award punitive damages in this case. And let me start, for example, with just gross negligence at the pleading stage. I bring this up because it was clear in the case below that the plaintiffs and its counsel made clear, the tenant and its counsel made clear that it was traveling under the intentional misconduct aspect of punitive damages, not gross negligence. Yet the trial court, in paragraph 10 of its order, provided the following. From plaintiff's perspective, the conduct could be viewed as so reckless and wanting in care that it constituted a conscious disregard or indifference to the rights of the plaintiff tenant. citing 768.72 parens 2 parens B, which is the gross negligence definition. Yet, the pleading doesn't mention negligence. The pleading doesn't refer to a duty. It doesn't even refer to a breach of that duty. And under that circumstance, to the extent the trial judge used that basis, the gross negligence basis, and it didn't have a complaint to support it or any facts definitively supporting it, that's reversible error. We don't know how much the trial judge relied on that aspect to support his analysis of punitive damages. And certainly, in terms of gross negligence,
What do you make of paragraph 9 of Judge Sherritt's order? Plaintiff has proffered evidence from which a jury might reasonably conclude the defendants engaged in fraudulent misrepresentation or fraud in the inducement. Does that not is that not ringing in tones of intentional conduct?
now that goes, and the analysis then has to turn not to gross negligence, obviously, but to the definition of intentional misconduct under the statute. And in order to establish intentional misconduct, a complaint needs to assert facts that would support the establishment of both knowledge of the wrongfulness by my clients of their conduct, as well as knowledge of a high probability of harm to the claimant. And I submit to this court that based on the facts alleged, they failed to meet that burden. And let me explain that.
Counsel, answer one question for me. Under the terms of this negotiation and this contract, what is your definition of a smoothie?
A smoothie, some form of cold drink. I apologize, Your Honor, I don't drink them, but some sort of a cold drink, yes.
Okay. Well, I've drank them, and it's amazing to me how when I pay $8 for one, it tastes far better than when I make one at home. But that being said, it sounds like, and it seems to me like that word smoothie was used a lot and was the center point of the negotiation pre-contract, and then it certainly appears, and it appears to me like there was a direct approval that this appellee was going to be permitted to at least begin the contractual agreement selling smoothies. Wasn't the menu attached to the contract when the contract was signed?
Not necessarily attached to it, but yes, first page, there is a specific definition of what they're entitled to engage in, which is the sole purpose. It's the sole purpose paragraph for which the space can be used, and it mentions their menu and then specifies those things and specifically mentions smoothies.
And it says also additional items must be approved by your client, correct?
It says all menu items. It doesn't say additional menu items. It says all menu items are subject to approval by mall management.
Okay, why wasn't the execution of this contract by your client with reference to the menu that was originally provided by the appellee de facto approval of their ability to sell smoothies at this mall?
There's certainly, I don't back away from the concept that they initially gave approval. That's correct. But that changed. And let me also point out that
they can enter. I'm sorry, go ahead.
That changed because your permanent tenant expressed displeasure with the fact that they were selling so many smoothies to the exclusion of your client, correct?
I don't know
the permanent tenant, I'm sorry.
There was an objection. I don't know the definitive motivation, but I think I'm not going to try to argue with that. Yes, but the contract allowed us, or at least it's our interpretation that the contract allowed us to take that approval back. All menu items are subject to approval by mall management. And I want to mention two things.
So your position is, I'm sorry to interrupt you. After approval is granted by the execution of the contract reference to the menu, specifically smoothies, that your client has the unilateral authority to withdraw that approval?
Yes.
Is that a breach? Would that constitute a breach?
Potentially, but it could, yes. It could potentially, in the event that for some reason the court.
We're asking a lot of potential tenants, aren't you?
Excuse me?
That viewpoint would ask a lot of potential tenants, hey, come on in, we agree, and we can change it at our decision, help me.
I think in the industry, if for some reason, in the industry, the landlord needs to have that kind of control over its menu. The menu of the things that the tenant, provides. I mean, I don't want to take it to the absurd, but what happens in the event that, they sell smoothies and they have problems with them? People are getting sick. Tenants should have the ability to say, don't do that anymore. And that's what they built into this contract. But I don't even need to rely on that because this isn't a breach of contract case, but I tell you, it should be a breach of contract case. And that's why, and to go to Judge Wallace, your point, they initially, intended to allow them to sell smoothies. They did allow it. And the record is undisputed, but the complaint actually makes that clear. First, it's that, the temporary lease attached to the amended complaint gave the right to sell smoothies subject to landlord's approval. That's undisputed. That's what they allege. And in paragraph 27, they allege that that false representation, which they're claiming is we have the right to, we were represented, we could sell smoothies. That representation is directly in the contract, and it was honored for almost 9 months, and it's specifically outlined and confirmed in the allegations of the complaint, which is significant, that they did in fact sell smoothies for almost 3 months. It's about 3 days short of 3 months. And yes, an objection was raised, and yes, they approached, my clients approached the tenant and asked them to stop selling smoothies. But the complaint establishes that the purported false statement, you can sell smoothies, in negotiations that was incorporated into the contract was honored. It wasn't false. That's what it means. And therefore it's not actionable. And to the extent that we believe, our side believes that they had the right under the contract to revoke that approval, the complaint acknowledges it. In paragraph 27B, the amended complaint admits that both Burris and DeCharia believed that under the terms of the temporary lease, they had the authority and right to demand that a temporary tenant change their menu at any time to satisfy the demands of another permanent tenant. If they believe they had the right, in what way do they have the actual knowledge of wrongfulness? They don't. And the complaint says that they believed. And then,
I don't want to put words into the appellee's mouth. I believe Mr. Korn's perfectly capable of straightening me out here as far as their position. But my impression is that their position is this whole discussion about smoothies was a misnomer or misleading, and you have to take into account the evidence that they have from the previous tenant. I guess it's Juice Me Too is the name of the previous tenant, where there was a question made of your client, why did that lease agreement come to an end? It was because the quality of their food was less than, but yet there's evidence and there was deposition testimony presented before the trial court that wasn't in fact the case of what happened. Well, there's the other question where once your client requested that they stop selling smoothies and the request was made from the other side, can we speak to your legal counsel? There was, from what I can tell from the record, there was no response. It was just a termination of the contract. So all of those things, to me, doesn't that in some way approach the level of reasonable basis for pleading of punitive damages? We're talking about pleading punitive damages, which I understand once you plead the punitive damages, there's a whole nother financial aspect of discovery that takes place when you do punitive damages. That's why we have that initial hurdle that you have to cross. However, all of that evidence to me begs the question of, did you even have a contract? Did one even exist with regard to smoothies and the relevance of that particular menu item before you entered into any sort of written agreement?
Well, they haven't pled, lack of consideration or that there was no contract. They haven't. That's not part of their pleading. But to go back to what the evidence showed on the evidentiary component as to the intentional harm component, they again have to establish both knowledge of wrongfulness and a high probability of harm. Knowledge of the high probability of harm. And I can walk through that evidence and establish that neither of those prongs are met here. Obviously, knowledge of the wrongfulness is, and it's undisputed in this record, that the tenant sold smoothies for almost 90 days. Well, far longer than the minimum 30 days that they were entitled to before either party could terminate on 30 days notice in their sole and absolute discretion. And the appellees don't contest that we complied with the aspects of the contract in terms of termination. And they say that in paragraphs, in pages 7, 29, and 30 of their answer brief. Now, going to this idea of how they try to use the prior situation with Juice Me Too and Ms. Flanders, the owner, the evidence that's in the record confirms that my clients weren't part of those negotiations. And for that, I rely on the depositions that were put in of my clients by the plaintiff. I also rely on the Landers deposition, Ms. Landers' deposition, granted, put in by my client, but in the record prior to the hearing, and we put it in there, and certainly as part of the rule of completeness, it should be considered. But in that, she confirmed that my clients weren't involved in those negotiations. That my clients, and that's at page 16 through 17 of her deposition. She also confirmed that the appellants did not make any misrepresentations to her. How can my clients be engaged in this reprehensible conduct if they weren't part of those negotiations? Their theory is that that my clients were, but the actual evidence proves otherwise.
And counsel, was there, so skipping back to the fraudulent inducement, the initial claim, was there a duty for them to disclose what had occurred with that prior tenant, whether or not they were involved or not? Was there some duty on them that they needed to tell appellee that why they left, or if they knew?
Absolutely not. It's not pled. It's an affirmative misrepresentation case, and that's all that's pled. There's no assertion of duty to disclose, nor could there be. This is an arm's length transaction. There's no fiduciary relationship. There's no additional duty to disclose. It's not pled, and there is no evidence to support it. Particularly when you look at the concept of, what were they promised, and what did the tenant agree to? They agreed to a temporary lease that could be terminated by either party in their sole and absolute discretion on 30 days notice. Either party. And there's even built into the contract, it says that was agreed to specifically for the purpose of giving flexibility to both sides. And under that circumstance, you can't assert and claim that there was some sort of knowledge of wrongfulness. They had the ability, and the only thing they could look forward to under the temporary lease was being able to sell smoothies at a minimum no more than 30 days.
Counsel,
and they
you're
got
just
that.
under 2 minutes left.
All right, well, thank you. In terms of the other evidence, I just want to track it very quickly that confirms they didn't meet the intentional harm prong. Tenant's proffer says that my clients were, at all periods of time, involved in all of the claims and factual assertions below, but my client didn't negotiate it. Mr. Burst didn't negotiate it, and Ms. Landers confirmed that she never spoke to my client until after the lease was signed in that Juice Me Too lease. Same thing with respect to Mr. Charia. And I'm relying on pages 16 and 17 of Landers' deposition, as well as the pages that we cited in our brief. that Mr. Chartier didn't even start coming back and working at the mall until well after that prior lease was signed. And then, in terms of this idea that our clients had to, inform the tenant that, someone might object, well, no knowledge of harm, because it's undisputed that the Juice Me Too situation, when that happened, our clients were able to work it out and allow them to sell smoothies, the same product, under a slightly different name called cold cups. And the objection had nothing to do with her termination. It was terminated in terms of another permanent tenant. I'll reserve any seconds I may have left. I apologize.
Mr. Corn, you may proceed.
Like prior counsel, I don't want to.
No problem.
Thank you, Your Honors. May it please the Court, I'm Michael Korn of Korn and Zener in Jacksonville. I'm with Connor Walker and co-counsel for the appellee, Roots and Fruits Juicery. Let me just point out one thing at the very end of counsel's comment, where he was trying to insulate Mr. Burris from anything relating to Juice Me Too. When you look at the lease that Ms. Landers signed on behalf of Juice Me Too, and you look at the signature block as to who signed on behalf of Avenues Mall, whose signature will you see? Onassis Burris. And even if he was not directly involved, or if Mr. Charrier were not directly involved in negotiating with Ms. Landers, they certainly knew of the circumstances under which Ms. Landers and her company ultimately left the mall, leaving a vacancy which they wanted to then try to fill yet again.
But Mr. Corn, was there a duty to disclose that?
Whether or not there was a duty, they undertook an interesting, it's kind of like we all learned in law school about, you can stand by the water bank and watch the fellow drown, but if you attempt to rescue him, you have to use some level of due care. Well, what was interesting here is they specifically told the owners of Roots and Fruits that the reasons that Juice Me Too failed was not because of the disputes or complaints from the Smoothie Shack, the permanent tenant who asserted the complaint, but because it was a bad product, or because they weren't a good operator. Counsel said in the reply brief we didn't substantiate that. I'll point out at pages 561 and 562 of the appendix, as well as pages 322 and 323 of the appendix, you'll see the deposition testimony where that was asserted. And what's interesting here, Your Honors, and this is kind of an interesting philosophical part of the analysis that this court needs to bring to review of the gatekeeper role that the trial judge ruled in. This is not a mini trial. This is not, and the Supreme Court has made that real clear, even as late as last week in the arguments that they held in the Perlmutter case, which was the fourth DCA case, which establishes some slight variance in the standards between what the fourth has been holding and what the fifth, I think a very robust body of jurisprudence on this very issue has held, as late as Judge Sal's recent concurrence in Medfast. Here, it's not supposed to be a mini trial. What is the trial court's duty under 768-72? Determine, is there a reasonable standard, has the plaintiff met the reasonable standard? Has sufficient evidence been proffered? And of course, we discussed in detail in the brief, what is a proffer? Just as Judge Wallace asked, what is a smoothie? And I'll try to answer your question in a minute, Judge. But what's the proffer? The proffer here was more than adequate. It can even be simply statements which don't have evidentiary basis, which would be ultimately admissible at trial, but the plaintiffs did more than that. They certainly met the standard that the statute requires. They certainly gave the trial court more than ample support, which is found in the order that the trial court entered. Judge Wallace, you asked a really interesting question. It's one that's kind of bothered me throughout this whole case, which is, what is a smoothie? And I think we even defined it in our brief from Merriman Online. And it's specifically, as Your Honor noted, specifically noted on the very first page of the lease, amongst all the other juice products and other things, is smoothie. So a smoothie, so what did they try to tell Ms. Landers when Smoothie Shack objected before? Oh, just call it a cold cup. It'll be okay. this is the type of practice that has been going on here. Call it a cold cup. We won't call it a smoothie. Maybe that fella in the other store in the mall won't figure it out. Well, here, this is not a breach of contract case. Counsel says it ought to be. He'd like it to be. It's not. As such, the independent tort doctrine does not trigger.
Why is it not a breach case?
Because the harm occurred when Burris and DeCharia induced Roots and Fruits to come in, assured them that their menu and their product line was entirely compatible with what the mall was looking for. And that goes to one of the questions that was asked earlier about, well, didn't you, by signing this lease and including the term smoothie in the permitted menu items, de facto permitted? And they sure did. And so why is it not a breach of contract? Because had my clients known that just weeks or months after spending over $200,000 simply in building costs and relocation costs, that the same fella at Smoothie Shack was going to object, would they have made that same decision? So that's the gravamen of the fraud and the inducement. And we went into, I think, some significant...
So your position is that the actual tort occurred before the contract was signed?
That's correct, Ron. But the evidence, the indicia, of course, we then later learn. And the case law is pretty clear when analyzing these fraud and inducement cases that of necessity, you don't learn about the evidence, you don't learn about the underlying facts that the tortfeasor knew or should have disclosed until after the events have all taken place. Otherwise, the whole inducement thing is negated.
So is there no obligation on your client to, because I believe, and I could be wrong on the record, but I believe that they raised the issue about Juice Me Too, that what happened to them, aren't we similar? So there's no obligation on them to do their own due diligence to say, maybe I should contact them. And I'm not saying the facts are not desirable, and it's not something that, the optics aren't great. But does that, in and of itself, make it a duty on the appellant?
No, Your Honor, I don't believe so. It's kind of akin to the construction litigation area of, what is the homeowner's duty to disclose as far as latent defects, et cetera. Here, not only we have a dual level of misrepresentation, and it bridges the event that Your Honor just identified. The first misrepresentation is, let's get these guys in, maybe they'll get by, and even if they don't, so we filled the mall space for a few months. But the subsequent misrepresentation is then when the issue comes up and my clients ask, well, what about this other operator? Oh, they had a bad product. Oh, they just didn't have a good operation, they didn't run it right. Both of those events then bookend the initial tort, if you will, and it was further indicia, and it goes to the issue of then, well, why? Were they entitled to then rely on the second representation? Because again, two representations. One, your menu is compatible, and we will allow this product line to come in. They went to our store, they sampled the smoothies. They were very much aware of the excellent reputation that our client had in the local Jacksonville area. So they knew all of this. And then when the Juice Me Too thing comes up, says, oh, don't worry, those were bad actors. You'll be fine. I think that addresses Your Honor's question, and I think it supports affirmance in this case, precisely because it goes to the issue of misrepresentation. Precisely. And another point that I wanted to build on, I think Judge Wallace observed at the conclusion of his questioning of counsel. As soon as my client was told, you can't sell smoothies anymore, and they asked, well, who's the lawyer, who's the general counsel that we need to talk to about this? Next day, the lease is canceled. So, the appellant wants to hide behind this whole idea of, well, we had a temporary lease, we could cancel it at any time with 30 days notice. Just a little suspicious. One day after, the Roots and Fruits folks are now trying to figure out, well, what exactly are our rights here? Who can we talk to other than this fellow at the mall? then they get the termination notice. It wasn't because they were bad operators. It wasn't because they were breaching the lease. It was because of a purposeful business decision made by these actors.
So if your client's claim below sounds in fraudulent inducement, is it overly simplistic for me to view the case and the record as that your position on behalf of your client is that the mall and its representatives entered the contract intending to pull the smoothie rug out from under?
I believe they did, Your Honor.
Right,
And
so
and I think that for purposes of the pleadings where we are now, it'll be our burden to prove that. You know, again, going back to this isn't a mini trial comment. It'll be plaintiff's burden to prove that at trial. We've already, as Judge Cobain observed before, we've already survived the motion to dismiss stage on the main claim, which I think defeats the whole independent tort concept. And so we'll have to prove it.
All right.
I mean, we look forward to proving it.
So then ultimately, if that is a proper way for the court potentially to look at it, do you concede your friend's argument that you were traveling below under intentional misconduct, not gross negligence? Only intentional conduct, not gross negligence.
I would not concede that, A. And B, when the traveling under theory, the case, of course, as Your Honor knows, has not yet been finalized as far as discovery, and it's entirely possible that the pleadings for purposes of trial could be amended.
No, I understand that, but you're asking for permission to assert a punitive damages claim right now.
That's right.
So, in other words, the theory has to at least be presented. But, and I agree with the pleading component, evidentiary component, and you got to do one before the other, certainly. But your position is you're traveling under both potentially.
Yes, sir.
All right.
Yes, sir. And I believe that's what that the trial judge appreciated that fact when he considered the proffer and entered the order that, of course, the court's already seen.
So then let me ask you specifically, and then I'll be quiet, and my colleagues who are much smarter than I am can ask better questions. Paragraph 12 of Judge Sherritt's order says, Florida law makes clear, in the context of commercial torts, proof of fraud sufficient to support compensatory damages necessarily is sufficient to create a jury question regarding punitive damage. In other words, one comes with the other. That's what I read that to say. If you can survive a fraudulent claim for compensatory damages, then if I'm reading his order correctly, then you can necessarily survive a punitive damages motion. Fair? Fair reading?
Well, that's what the order says. I would suggest that it's surplusage for purposes of our analysis right now, because I think the key findings, Your Honor, are found in paragraphs 6 through 9 of the order, where Judge Sherritt, in fact, goes through the actual proffer. And so whether Abelinado was satisfied or the Cates case that he cites, it's surplusage to the correctness of the underlying gatekeeper function that the trial judge did.
I think one may exist without the other, but if the gatekeeper says if he can survive a compensatory claim for fraud, he can necessarily survive a claim for punitive damages, and I'm going to, as the gatekeeper, under that precedent, necessarily allow him to amend, that at least draws a question of analysis, because that was not addressed in the MedFast, either the panel opinion or the concurrence. Certainly the Supreme Court with Perlmutter, I think, has an opportunity to provide clarity to what, and I think even Chief Justice Muniz may have recognized there's perhaps not a lot of cohesiveness amongst the districts on punitive damages cases, standards, and analysis, and even within districts, potentially even the fifth. And I'm just trying to wrap my arms around that aspect of our analysis, because it seems a tenuous proposition to just blanket say, if you have enough for fraud for compensatory damages, you can survive a motion for punitives.
And I would respectfully submit to Your Honor that that portion of the order is not dispositive of the court's analysis. In other words, because if that was the case, then there would be no gatekeeper. He wouldn't have even had to make the findings in paragraph 6 through 9, right?
Yes.
And so to the
Concerning.
well, but to the extent that I think what was the old principle we learned, that the specific should overrule the general. I could argue that paragraph 12 is kind of a general statement, flawed or not. Paragraphs 6 through 9 are specific, and they're keyed to the evidence as proffered. And they established not only that our pleading was proper, but our evidentiary basis is sound. Because otherwise, you wouldn't have needed to have made the finding that we had proffered evidence that Burris and DeCharia at all times material had acquired knowledge and understanding of the circumstances surrounding the termination of the Landers Juice Me 2 lease, that they did not disclose obvious circumstances that would, I'm quoting now, predictably impact plaintiff's business model and lead to termination of the lease agreement, and that it was foreseeable that the plaintiff would be induced by and detrimentally rely on the stated compatibility of its product menu.
Counsel, can you give me a hypothetical of a claim for fraud in the inducement that you think survives a motion to dismiss and does not get a punitive damages amendment if it's requested?
Well, that's an interesting question, Judge.
I agree.
You wouldn't have asked it otherwise.
Yes, because this is sort of just a regurgitation of the elements of fraud in the inducement. But it doesn't tell me anything, and it doesn't, and then this citation, which is a different issue, it's a directed verdict, I think it's distinguishable. But be that as it may, I think that it is a difficult situation where you have a collapsing of the gatekeeping function a little bit, and in an intentional tort context, because this is a commercial lease. This is an arm's length transaction. Again, the optics are not desirable, but that in and of itself may or may not be enough. This is a motion to dismiss, which is immediately, then there's an amendment. So what are we to do with that?
I suppose, let me try to address it. I probably won't do a very good job as to your hypothetical. As to your hypothetical, let's say that that the mall manager and the mall salesperson, Mr. Charia, had gone to my client and said, "You'd be great. You'd be great in the mall. We need this kind of product." It would appeal to female customers, which again is directly out of the record, by the way. But they didn't know or didn't say anything about Juice Me Too. I could say that there could be a hypothetical that you could say, well, maybe there was fraud in the inducement for purposes of compensatory damages, but the knowledge that they'd already done this to another vendor, another tenant, could theoretically, again, we don't have all the facts of that case, so it's hard to be able to flesh out the particulars of a hypothetical, but I could see potentially someone, if they were rewriting the facts, which we're not doing, of course, and neither can this court. If you were rewriting the facts, you could say, well, maybe they misrepresented certain elements of what compatibility would look like and what we might do, but they didn't have the knowledge that this act had already been played out. That might be one potential hypothetical for your Honor's consideration as to, is there always an overlap? Is there always, if there's fraud inducement, there's always punitives? That's why the gatekeeper role is important. And the trial judge, I think, did a very appropriate and sensitive job in fulfilling that obligation by considering the testimony, the depositions that had been developed to that point. I don't know if that addresses your Honor's hypothetical question, but I could see gradations of fraud. Elements of fraud. Just how stinky was this fraud, if you will? Where you could say, fraud for compensatory purposes, but perhaps it doesn't rise to the level of punitives. This case fits the second scenario. It does rise to the level of punitives. It at least rises to the level that we've made our burden, we've met our obligation, and then as I told Judge Sal, then now let us go prove it.
And what do you think about your opposing counsel's thoughts on whether or not we can look at the pleading, the amendment, we can look at the pleading itself and say whether or not you stated a claim for fraudulent inducement? Well,
we've already had, the judge has already had significant motion practice on that very point. What they want, in essence, is a second bet, a do-over on what they lost on the motion to dismiss, which of course is not reviewable at this point. For purposes of compensatory damages, it is they're stuck with that. They're stuck with that. The purposes for the amendment, we weren't amending to create some different theory for which we would obtain compensatory damages. We were following the requirements of section 768.72 by asking the court's leave to amend to do what? To seek the punitive damages. It doesn't mean that we undid the theory and the evidentiary basis for which compensatory damages were collectible. It's not etch-a-sketch. It doesn't go away.
Right, I see what you're saying, and I'm trying to understand. It's a bit of a circular situation, because you have a singular intentional tort claim that now almost naturally feeds into and requires a punitives claim. But it all hinges on this one claim. So if that claim is not properly in the court, because it should have been dismissed just hypothetically for, because the independent tort doctrine. Now you get all the way to the end of the trial, and now you go back. And you can only have one operative pleading at a time. I think we would agree on that. So you've moved to amend. Yes, you've moved to amend to assert a claim, but does that not open it all up?
Your Honor, respectfully, I submit it would open it up simply for the consideration of the punitive damages. They've had their argument on independent tort. They lost. They lost correctly. It's not reviewable now. If they want to review that at some point when judgment's entered, so be it. My time has expired, and I thank the court for your very thoughtful questions. Hope next time I'll think of a better answer to your hypothetical, Judge.
Mr. Corn, I will note that
indulging me.
it's not always that the judge asks the attorney to provide a hypothetical, so. Yes. Counsel, because it's October 14th at 10:30, I'm going to give you a full minute to respond, even though you don't have that. So.
All right, well, thank you, Your Honor, very quickly. First and foremost, proof of fraud for compensatory damages does not satisfy the requirements for punitive damages, and here's why. You also have to establish knowledge of a high probability of harm to the claimant, and that's not an element. That's not an element of fraud. You don't have to have that. You may have to have intent for reliance, but you don't have to have knowledge of harm, and that means you don't. Just pleading fraud for a compensatory basis isn't enough. Second, my colleague told this court that there were 2 misrepresentations made. On compatibility, that's not in the complaint. There's one misrepresentation, and that is you can sell smoothies and the rest of your menu. And we already know they did. To assert that there was an intention not to let them sell smoothies when they were allowed to smell smoothies for 90 days, or almost 90 days, is just, it's proven to be false at this stage, based on the undisputed evidence in the record. The assertion, they've done this to another client. When you go through the deposition of Ms. Lander, she confirms that my clients were not involved in those negotiations, did not make representations to her.
Counsel, your time is expired.
Under those circumstances, we would ask that this be reversed. They can't establish the wrongfulness under those circumstances.
Thank you, counsel. All right, counsel, would you please just provide the audience with the benefit of your background and kind of similar to what happened before, and we'll